Hello friends, with the initiative of Company Law Institute of India Private Limited, the series which we have started for the income tax cases, in that series, today we will discuss a very important case on section 148 proceedings. The name of the case is PRAKHAR TANDON versus Assessing Officer and others, and this case has been reported in 448 ITR at page number 177. This case has been decided on 6th May 2022. The whole case is regarding a writ petition filed by the Assessee against the assessment order passed under section 147 read with section 144. The facts of the case are very interesting. In this case, the notice under section 148 was issued to the Assessee. When the Assessee asked for the reasons for section 148 notice, it was told to the Assessee that the Assessee has sold some property on which the Assessee has earned a capital gain of near about 26,02,150. The Assessee vehemently objected the reasons and said that during the financial year the Assessee has not sold any property and the reasons recorded are unfounded and baseless. When the assessing officer went through the objections of the Assessee were disposed in a hyper-cryptic manner and the objections were disposed of in a negative manner, meaning thereby that the objections were not considered, and after that the ex-parte assessment of the Assessee was done. The beauty of this case is that when the assessment order was written, in that assessment order the sequence was like this. First of all, the details of the notice were issued, were there. Then what are the objections raised by the Assessee were printed, and then how these objections were disposed of by the National Faceless Assessment Center. All this story was there. This story was all about the sale of the property, the objections of the Assessee, and the disposal of the objections by the National Faceless Assessment Center. But the beauty of the order was that in the last lines of the order, the whole scenario was changed, the whole story was changed, and the addition was done by saying that the Assessee has purchased the property worth rupees 10 lakh and this is from an unaccounted money, and the addition was done accordingly. The crux of the matter is that the reasons were about the sale of the property, but the addition was regarding the purchase of the property. So the whole assessment order was vague, unfounded, based on non-existent reasons, and was not bona fide. The Assessee filed the writ petition. As usual, the department was contesting that the Assessee has the alternative remedy, so the writ petition of the Assessee should not be entertained. But the Allahabad High Court came very heavily on the department and said that this is a classic example where the department authorities acted without jurisdiction, arbitrarily, and to harass the Assessee. The court also came with the remark that it has become the practice of the department to harass the Assessee, which needs to be checked by the higher authorities. Friends, as we know that the main pillar of section 147 read with 148 assessment is that whenever the notice is issued, there should be some reasons to believe, and these reasons to believe should be based on the material available with the assessing officer. In this case, whatever the information was available with the National Faceless Assessment Center, they were saying that they have received this information from the Inside portal. As all we know that the information which is coming by filtering from the Inside portal is nowadays is without checking with the returns filed by the Assessee, and whenever the notices are being sent to the Assessee, the credibility of that information is not checked in relation to the Assessee, due to which the Assessees are now bearing the heat of section 148. Earlier it was 148, now there is some procedural changes which are in the form of section 148A, clause B, clause D. But With the introduction of all these changes, the life of the assessee has become more hell, because now there is a lot of litigation, there is a lot of confusion, and the National Faceless Assessment Center is behaving in a very erratic and illogical manner. So in this particular case, the Allahabad High Court came very heavily on the department. At the end of this video, once again I am repeating the name of the case. The name of the case is PRAKHAR TANDON versus Income Tax Officer and others. This case has been reported in 448 ITR at page number 177, and the matter has been decided by Allahabad High Court. Thank you, friends.